second video in our 5-part series discusses how to better prepare for your death with your family while you're still alive. I know these are very difficult discussions to have and even thoughts to process, but your family will be very thankful once you're gone. It'll give them the opportunity to grieve in peace. Unless you plan to seek revenge from the great beyond, take a listen. So throughout the course of my career, Erica, I have had several deals where people are dealing with the aftermath of either someone's passing or having to deal with a family member who's become incapacitated and all the fun stuff as far as being a trustee or dealing with an estate. What are some things that you can share with us as far as people getting ready to help their family through those times?
Well, it's really so critical that people be proactive about their estate planning. And if it's nothing more than planning out how they're going to deal with their real estate, I mean, maybe they can't make decisions about their personal property. Maybe they can't make decisions about their end-of-life preferences. But if you make decisions about how you're going to deal with your real estate, it really makes it easier on everyone, on your kid, on your spouse, on your kids, on anyone else who has to deal with liquidating that real estate at the end. So estate planning, at a minimum, should be making sure that the real estate is addressed.
And when you're making these plans, what are some things that you take into consideration?
So there are a number of different ways that you can do estate planning with your real estate that just make things so much easier for your family. You can put the property in an Illinois land trust and then name your beneficiaries, name your successor beneficiaries, and the property can be transferred out of the Illinois Land Trust by the beneficiaries, the successor beneficiaries, without having to go through probate. You can make sure that your property is in a personal trust if you're ready to do the commitment to make a personal trust, and then the property would be deeded out by the successor trustee, because generally you're your own trustee. It would be set up by, be able to be deeded out by your successor trustee. And the third way is to set up a transfer on death instrument, or a TODI, which establishes who is entitled to the property after you pass. It automatically goes to that person, and you don't have to go through probate. If you don't have any of those things set up, very likely you're going to have to probate the property, unless the property's been set up in a joint tenancy or tenancy by the entireties, so it immediately passes to the other joint tenant. But if you're the last owner of the property, having thought through the way that you want the property to transfer without having to go to court and spend $8,000 to $10,000 on making sure that that property can transfer out, really is pretty critical for a homeowner. And that's something that someone should think about no matter what their age is, that they've already thought about how to handle it. We often talk to young buyers, now that you have this asset, make sure you've considered what it's going to do for your children, what it's going to do for your family, and that you've thought through at least the basic minimums of what will be necessary to transfer the property without having to spend thousands of dollars and eat up the equity to get that done.
Follow-up questions that I thought of while you were talking. Number one, whether you are starting a family, thinking of starting a family, like no age, no matter what age, because life happens and people can get ill. That's something that people should be thinking about, so that if they do have family members and loved ones, that they're going to leave behind what's going to happen to the real estate. What would you say the surviving family members can look forward to if their family member hasn't, or their loved one hasn't, gotten things prepared? Dealing with probate, how does that look?
Sure. So if a property, any property over $100,000, which most real estate is, has to be handled either through one of those methods that I've suggested, or it will be handled by getting a court order from the probate court. There's one other possibility, and that is if all the heirs agree and the title company will insure over it, you can transfer title on a affidavit of heirship. Affidavit of heirship is where all the heirs agree that they're the only parties that could possibly inherit, and they all agree on how the property should transfer. That assumes that all the heirs agree. That assumes that all the heirs it assumes that all the heirs can be located. I had an estate recently with 12 heirs. We could not get that property transferred before a sheriff's sale in a foreclosure because we couldn't deal with the title issues of who had to sign the documentation.
And we just dealt with a transaction recently together where the seller, we were representing the buyer, and the seller was one executor of the estate, or one trustee, and there were 5 people making the decision, because that's just how things work in the family.
Yeah, and it slows the process up. And generally what you want to do in a real estate transaction is move within the normal 30 to 45 day time frame. And if you've got a lot of decision makers, you're going to have a much harder time getting to conclusion on it. And buyers will walk away. Buyers will get frustrated. You know, one of the terms of termination of a contract is not closing on the date that you determined you were closing. Yeah, you need people cooperating with each other if you're going to get the real estate sold.
Another follow-up question that I had was, you know, it's become such a global economy and people are investing out of state. Are you able to, when you're preparing paperwork, are you able to factor that in there? So if somebody has investment property in Arizona, but their main property here is here in Illinois, are you able to factor that into the paperwork?
Well, you can if the property, if there's a will, if there's a trust. Mm-hmm. Otherwise, what you're going to wind up with is an attorney handling things in Arizona and an attorney handling things in Illinois and any other state that the property is in.
But the document can be worded as such. You just have to get an attorney in each state.
Correct. If the document is worded in a way that explains how the disposition will be, then that controls.
If you found this video to be informative and helpful, please show some love and hit the like button. Be sure to subscribe and click the bell so you can catch our next video where we talk about what could happen if you don't have your papers in order. Believe me, it's not fun for the loved ones you leave behind. If there's something you feel that we didn't cover or you have a question or comment, feel free to leave it below. Thanks for watching, and we'll see you next time.